three points I want to highlight. Proposition being a more restrictive and strict approach in interpreting Article 370 for three reasons. I'm taking the broader view because the nuts and bolts have been gone into. The first reason is historical. The second is jurisprudential. And the third is in terms of the constitutional ethos. The historical part, my lord, which I'd like to emphasize for a more restricted and strict interpretation is that the region consisted of a Muslim majority. And the population, my lords, had a choice between either going into Pakistan or into India, either being a majority in Pakistan or choosing to take a minority status in India. My lords, it chose the latter. And my lords, although the historical part has been dealt with about the signing of the instrument of accession, just a few pages I'll highlight to show how it was Sheikh Abdullah who represented and who had a hold over the population at that time, who was responsible for this transition to India. And therefore, my lords, one of the important points which I'd like to make is that if there is a choice, a conscious choice made to remain a minority in a region in the backdrop of the horrific violence of partition, my lords, when there's a constitutional promise in the nature of Article 370, it should be strictly construed. That's my first point. And my lords, in regard to that, my lords, may I just point out 2 or 3 pages, VP Menon's book on the integration of the nation state. I'll just point out the pages so that I don't take time. My lords, page at volume 15, PDF page 1258, where it just mentions that Sheikh Abdullah rose to power to fight for the rights of the Muslim community. By 1939, the body had shed its communal complexion and changed its name to National Conference. He had a considerable hold over the people of the state. That is B.P. Menon's book at page 1258. Then, my lords, may see page 1259 PDF. The Maharaja was assured by Lord Mountbatten that if he acceded to Pakistan, India would not take it amiss and that it had a firm assurance of this from Sardar Patel himself. Lord Mountbatten went on to say that in view of the composition of the population, it was important to ascertain the wishes of the people. This is PDF page 1259, volume 15. The situation for the Maharaja was not easy. This is again Menon pointing out. If he acceded to Pakistan, the non-Muslims of Jammu and Ladakh, as well as considerable section of Muslims led by National Conference, would have resented such an action. That is page 1259, PDF page 1259, volume 15. The government of India had no territorial ambition in Kashmir. If the raid by the tribes had not taken place, government of India would have left Kashmir alone. That is at page 1271, PDF, volume 15. The tribal invasion was not a spontaneous affair engineered by Pakistan. That is at page 1271, volume 15. The accession was legally made by the Maharaja of Kashmir, and this is important. And the step was taken with the advice of Sheikh Abdullah. That is PDF page 61, volume 20. This is A.G. Noorani's book, my lords. This is not, up to now I was stating Mr. Menon's book. This is A.G. Noorani. And then, my lords, may see on 27/10/1947, in reply to the request for accession by the Maharaja, the Governor General of India, Mountbatten, clearly stated that the issue of accession should be decided in accordance with the wishes of the people as soon as law and order had been restored in Kashmir. This is PDF page 59, volume 20. In the context of these historical facts, both Nehru and Sardar Patel were of the clear view that Jammu and Kashmir should decide their own consequences. See letter of Jawaharlal Nehru dated 18th of March, 1949, PDF page 67, volume 20. This is again A.G. Noorani's book. It is in this context, my lord, that 370 emerges. So, my lords, my first submission is this, in this context, that when there is a conscious choice made in this manner, my lords, all the more reason why it should be taken strictly. And in this context, may I just point out S.R. Bommai at page 218, PDF page 218, volume 2, which says that federalism is not seen merely as a matter of administrative convenience, but one of the principal outcomes of our own historical process and a recognition of ground reality. And my lord, this leads to what is called asymmetric federalism, my lords, which has been extensively dealt with by my lords in the NCT judgment 2. It is also, my lords, in fact, one of the first persons who coined the term asymmetric federalism in the Indian context was Professor Balbir Arora from Sorbonne, and he was also the professor for political science in JNU. And his book, my lords, which is at page 242 to 243, PDF page, volume 17 of the document compilation, where he talks about the nature of asymmetric federalism, which was there, which is to take into account different regional aspirations. And it has a remarkable degree of flexibility and pragmatism. It is a calibrated institutional response to the diversity of constitutional unit permeating both de facto and de jure variation. My lord, thereafter, my lords, may I just point out the above fact that it is an anti-majoritarian or a protection against majoritarian that asymmetric federalism provides. And in that context, my lords, our constitution is also a anti-majoritarian in many ways, my lords. There are lots of judgments which have dealt with it. I put it at point E.3 of my written statement at page 500. That is E.3 of my written statement. Then, my lords, Keshavan Bharti case at para 208, PDF page 151, volume 15, where I point out that where it is emphasized that in case there is a it quotes, my lord, the case, and I'll just quote it. I may mention that the Judicial Committee, while interpreting British North America Act 1867, had also kept in mind the preservation of the rights of minorities. For they say in the regulation and control of aeronautics in Canada, the British North America Act embodies a compromise under which the original provinces agreed to federate. It is important to keep in mind that the preservation of the rights of minorities was the conditions on which such minorities entered into the federation and the foundation upon which the whole structure was subsequently erected. The process of interpretation as the years go on ought not to be allowed to dim or whittle down the provisions of the original contract upon which the federation was founded, nor is it legitimate that any judicial construction should impose a new and different contract. This is echoed in Jindal Steel case at 2017 12 SCC 1, that is PDF page 219 to 220, where it is very clearly pointed out. Again, it reiterates Keshavan Bharti that the original terms should not be whittled down. And so, my lords, the argument that so-called hollowing out of the Article 370 through various orders which have taken place. Already, Mr. Nafe has argued that there was no hollowing out, the core remained. But assume that there was a hollowing out which takes place. It is a political act. And my lords, has been very clear in this entire proceedings that we are interpreting the Constitution. So if because of a political act, there is a so-called hollowing out, which is without prejudice to that argument, I do not accept that it is. But if there is such is the case, even then that should not affect the interpretation of the provisions of Article 370. Then, my lords, may Podwal case again highlights the aspect of asymmetric federalism, which I will not go into. My lords, the second point briefly, what are the limits, my lords, if you're looking at the broad approach, what are the limits by which we will determine what are the limits of a constitutionally vested power? And my lords, the answer is the analogy of Mill's famous thing on liberty, that your liberty ends where the other man's nose begins. So the moment there is a fundamental constitutional principle which is there, which is getting affected, the limit must be there. And my lords, in that context, the NCT judgment case, there are 2 pages I'll just point out, PDF page 92 at para 108 volume 5 and PDF page 35 at para 40 volume 14. My lords, also there is the Miller case, that is at PDF page 324 of volume 5, recent Miller case in the UK, in the context of proroguing of the House, where again this concept is put forward. So it's an international constitutional concept which is also equally applicable here. It has been reiterated by various judgments in India. My lords, I would also urge that if we are talking about minority rights, if we are talking about anti-majoritarian or protection against majoritarian, my lords, there is the LGBTQ plus judgments, etc., which are coming. There is an evolution which is taking place. With respect, my lords, this kind, if one were to do away with this thing which involves historically a religious minority, not that they are necessarily expecting, if that is there, my lords, it will be a regressive step. And my lords, in line with what is happening, in line with in which the evolution is taking place, more and more inclusiveness is there, it should not be there. I'd like to finally end, my lords, I won't take more time. I'd like to end by pointing out 1 or 2 quick points. One is, my lords, in our rejoinder at page 88, the Niti Aayog report is there. Now, my lords, there is no material which has been brought on why 356 was imposed. My lords, that has always all been argued. but the material of the government which is already there on record. It says in peace, security, effective governance based on rule of law and upholding principles of equality, Jammu and Kashmir rises above a number of states. And that I put at page 88 at volume 13 of the Niti Aayog report, page 282 of volume 13 at page 286 and page 285. This is prior to abrogation. So, this further kind of deepens the mystery. And of course, there are statements made by ex-constitutional authorities, not of much relevance now that he's not holding a constitutional post, but how it was exercised. But when this was the case, if Kashmir was a leader, it's used as a leader in these areas, where was the need for a 356? Finally, one last anomaly which my learned friend had also pointed out, and that is, I'll just point out that in volume 3. Sorry, just a minute, just on the reorganization. I'm sorry. Yes. We come to section 57. It's the botched up kind of situation which is arising now with this. Of course, the Reorganization Act is consequential, I understand, but still, my lords, I may just point this out. 57 at PDF page 126, volume 3. My lords, it says, notwithstanding anything to the contrary contained in any law, document, judgment, ordinance, rule, regulation, or notification on and from the appointed date, the Legislative Council of the existing state of Jammu and Kashmir shall stand abolished. On abolition of Legislative Council, every member shall cease to be, etc. So it abolishes the Legislative Council. Now, my lords, what is peculiar is, just before this, the CO 272 is passed. CO 272 applies all the provisions of the Constitution. When you're talking about abolishing the Legislative Council, then it has to be as per section 169 of the Constitution of India, which is already stands applied on pursuant to CO 272. Once that is applied, then what happens? It can't be done away by way of this act. So we've already challenged the validity of this act, but this is like a Trishanku, a legislative council, which has not been abolished by any proper procedure which is prescribed by law. So that was the point, and there was one more. 73, my lords, is that clause which has come even by way of amendment in the context of the Delhi government also, that if the president on receipt of a lieutenant governor, the same powers as 356, but no time limit provided. I'm very grateful, my lords, and I'm extremely grateful that my lords had this the technology which enabled us even many times, even while we were not present in court, we could keep in touch with the deeply obliged.